It is a pleasure to participate in this wonderful colloquium, and I think it's a necessary premise that I should thank Hélène and all the others of the organizing team for such successful discussion so far. We hope in our panel not to be below the very high level set yesterday and this morning. The subject of the present panel has been written in the program as choice of dispute settlement means in the law of the sea. And indeed, when you look at literature, especially the not too specialized literature, you will read that the dispute settlement mechanism of UNCLOS is characterized by choice of procedures. In fact, there isn't a lot of choice available. I think Michael Wood has made the point very precisely just a few minutes ago. Of course, parties have, I would say, an influence on which adjudicating body will adjudicate a specific dispute, because they can express their preference or preferences under Article 287. But at the end, in most cases, the decision as to whether it will be the ICJ, the ITLOS, or an arbitration tribunal is taken automatically by the rules, and in particular by the default rule of favoring arbitration. So it's not so much a choice of procedure, but a plurality of possible adjudicating mechanisms. And this, I think, requires to make an observation. The drafters of the convention were not too much concerned about the possibility of divergent interpretation of the tribunal because of different adjudicating bodies that could have to interpret the convention. All the discussion about fragmentation of international law caused by proliferation of international courts of tribunals didn't seem to excite very much the third UN conference. Some people, indeed, if you look at the preparatory work, there were one or two interventions saying, well, what will happen if an arbitration tribunal says one thing and the ITLOS or the court says something? But the decision was taken anyhow, that it was much more important to have a compulsory system, even with three or four different possibilities, than not to have it. The present panel will not, let's say, repeat the elementary points based on a comment on articles on the dispute settlement, and in particular Article 287. The present panel is much more ambitious. It looks at some less known aspects, especially of the past, and this will be done by Bernard Oxman, who is a great scholar, practitioner, and one of the main protagonists of the negotiation in the Law of the Sea conference. And then we'll look at something that is, we could label it the present, the very recent settlement, or almost complete settlement, of the Timor Australia divergence on maritime borders and other things, which will be illustrated by Natalie Klein, a great specialist from Macquarie University in Australia, a specialist in many things, including law of the sea, dispute settlement on the law of the sea. And then we move to something that is in the present, but mostly in the future what will be the dispute settlement to be agreed in the current preparatory commission on the so-called BVNG. And already this starts to be mysterious because many people don't know what this acronym means. And here we have Liesbeth Lijnzaad, which we catch at the very interesting moment of her career, because I think maybe she is still for 1 or 2 days the legal advisor of the foreign ministry of the Netherlands, and so a negotiator, and starting Monday, she will become a judge of ITLOS. So we wish you well, and I think without further ado, I give the floor to Bernard Oxman.
Thank you very much for that kind introduction. First, I'd like to join Tullio and others who have preceded me in thanking Hélène and Eric and all the others who worked on organizing this conference, for inviting me to attend and to speak, and also for the excellent hospitality that's been extended to those of us who have traveled from near and far to be here. Precisely because we are near the seat of a great judicial institution that ensures the rule of law within the European Union, it's important to stress that this should not be taken for granted. It is not the background norm in international law generally, at least not yet. Absent express agreement or express consent, there is no international court or tribunal with jurisdiction over a state. As Tullio Treves just suggested, the primary function of Section 2 of Part 15 of the UN Convention on the Law of the Sea is to provide such agreement and consent with respect to disputes concerning the interpretation or application of the Convention. The selection of a specific forum for this purpose, while it is of course important in securing consent to jurisdiction, that selection may be viewed as secondary to the objective of assuring that there is some court or tribunal with jurisdiction to render a binding decision, as Tullio just said. This was the perspective of many delegations during the negotiation of the Convention. A primary objective was the establishment of order, stability, and predictability in the law of the sea, which in turn required stemming the tide of unilateral claims that undermined that objective and threatened global mobility. Compulsory jurisdiction was viewed as a means to encourage compliance with the Convention, and thus as a helpful supplement to diplomacy and the exercise of rights in areas affected by unilateral claims. I was privileged to have a role in the formulation and negotiation of these positions, and that role earned me a memorable lunch with the venerable Judge Manfred Lux of the International Court of Justice, who served on the court from 1967 to 1993, and as its president from 1973 to 1976. Judge Lux tried to persuade me that the creation of a new standing international tribunal was a bad idea. Finding him unmoved by my arguments on the merits, I indicated that it was unlikely that we would be able to secure consensus on compulsory jurisdiction without the inclusion of a new standing tribunal. Judge Lux replied that this might be too high a price to pay. There were, of course, others who shared his skepticism about the creation of a new standing tribunal. Still others were unhappy with the idea of having to resort to any standing international court, including the ICJ. As Michael just indicated, this group notably included the leader of the French delegation in the Law of the Sea negotiations, Guy Ladré de la Charrière. France's position in this regard may well have been influenced by its experience with the original nuclear tests cases in the ICJ. La Charrière was not content with the compromise that emerged from an informal meeting in Montreux to the effect that a dispute may be submitted to the forum selected in the respondent's declaration, be it the ICJ, a new standing tribunal, or an ad hoc arbitral tribunal. La Charrière insisted not only on the right to be subject to suit only in an arbitral tribunal, but on the right to sue in an arbitral tribunal without regard to the respondent's declaration. In the course of yet another memorable lunch, La Charrière unambiguously conveyed his strength of feeling on the issue by assuring me that the failure of the Law of the Sea negotiations would not prompt a day of mourning on the streets of Paris. La Charrière succeeded. And of course, not without a touch of Gallic irony, he was later elected to the International Court of Justice. That said, supporters of a new standing tribunal succeeded not only in creating it, but in endowing it with jurisdiction over 3 types of cases, notwithstanding the declarations of the parties: prompt release of detained vessels and crew, provisional measures pending the constitution of an arbitral tribunal, and interpretation of deep seabed mining provisions. The first 2 of these are characterized by a need for urgent action by a tribunal, a need that cannot readily be fulfilled by an ad hoc tribunal that is yet to be constituted. These provisions, when you couple them with the role of the President of the International Tribunal for the Law of the Sea in appointing arbitrators where the parties have failed to do so, have proved significant in bringing the merits of a dispute before ITLAS in situations where ITLAS did not otherwise have jurisdiction over the merits under the declarations of the parties. The tribunal's very first dispute is instructive in this regard. Initially, St. Vincent and the Grenadines submitted a request to ITLAS to order prompt release of the Saiga, a ship detained by Guinea. The ship was not immediately released following the ITLAS order. St. Vincent then submitted the dispute on the merits to an Annex 7 arbitral tribunal and requested that ITLAS prescribe provisional measures releasing the ship pending constitution of the arbitral tribunal. In the course of consultations with the ITLAS president regarding the pending proceedings, the parties informed him that they had agreed to transfer the dispute on the merits to ITLAS. The agreement on transfer states that it emerged from, and I quote here, recent exchange of views between the 2 governments, including through the good offices of the President of the International Tribunal for the Law of the Sea, unquote. This case and subsequent cases, including one just decided a few days ago by an ITLAS chamber, remind us that choice of forum very much depends upon timing and context. Parties to the convention limited their range of choices at the time Article 287 of the convention was negotiated, but gave themselves options. Then they made a specific choice when they decided whether to file a declaration under Article 287 or to simply be deemed to have accepted arbitration under Annex 7 by not filing a declaration. While that choice had the effect of determining the forum absent further agreement between the parties, it did not, both in principle and in practice, preclude such further agreement following submission of the dispute. Or indeed, it didn't even preclude filing a new declaration. The inclusion of compulsory dispute settlement provisions in a major multilateral treaty, such as the Law of the Sea Convention, has a double function, as Attila noted yesterday. The primary objective, of course, is to ensure the peaceful settlement of disputes. But there is also a desire, at least in some measure, to provide for an authoritative articulation by learned jurists of what the text means and how it applies. In this regard, as Tullio indicated, one may ask whether there is a contradiction between the latter objective and the decision to afford a range of choices as to the forum. Isn't there a risk of inconsistency that is, at its heart, in tension with this objective? Now, because there have been a lot of maritime delimitation cases, we can test this hypothesis in the context of those cases. Those who feared what a new standing tribunal would do might note that in its Bay of Bengal judgment, ITLOS not only applied the three-part methodology articulated by the ICJ in its unanimous Black Sea judgment, but for the first time also applied that methodology to delimitation of the continental shelf beyond 200 miles. And those who wonder about the influence of arbitral awards on the development of the law might note that the award in the Anglo-French Channel Islands arbitration began the arduous process, eventually embraced by the ICJ itself, of walking the law of delimitation back from the open-ended indeterminacy of the standards articulated in the North Sea continental shelf opinion, or that the arbitral award in the Barbados, Trinidad, and Tobago arbitration advanced the development of a more coherent delimitation methodology along the lines the ICJ was already working out, and that it thereafter crystallized in its Black Sea opinion. A number of authors and speakers have noted this remarkable consistency, including Judge Greenwood recently. This remarkable consistency may be due to a variety of factors, and I think in particular the fact that judges and arbitrators are well aware of the desirability of maintaining reasonable coherence and consistency. It's also possible that the process is aided by what I might call cross-fertilization. For example, one or more current or former ICJ or ITLOS judges may be appointed as judges ad hoc of the other tribunal or as members of an Annex 7 arbitral tribunal. Also, as you've all seen, in an intriguing twist, perhaps, the agent for the Netherlands in the Arctic Sunrise case brought against the Russian Federation, we have the honor of her presence here, as well as the Russian ambassador to the Netherlands at that time, were both recently elected to ITLOS by the parties to the convention. The underlying approach of the Law of the Sea Convention, namely that forum selection is flexible, provided that some international court or tribunal has jurisdiction to render a binding decision in the dispute. That underlying premise, under the text of the Convention, extends beyond the Convention itself. Under Article 282, which has already been mentioned in earlier discussions, the Convention's compulsory jurisdiction provisions do not apply if the dispute concerning the interpretation or application of the Convention is subject to a procedure entailing a binding decision under another treaty. This would appear to be so whether or not there is an express reference to law of the sea disputes in the other treaty, so long as that treaty confers jurisdiction on a court or tribunal to render a binding decision in respect of that dispute. This presumably includes acceptance of jurisdiction to adjudicate or arbitrate disputes under treaties that establish particular standards that are incorporated by reference into the Law of the Sea Convention. Deference to the dispute settlement system of the other treaty is expressly required by the 1994 implementation agreement regarding Part 11 in connection with the GATT constraints on subsidies that are incorporated by reference. But it would seem that one might reach the same conclusion under Article 282 of the Law of the Sea Convention in any event with respect to other treaties that provide for compulsory arbitration or adjudication of disputes regarding standards incorporated by reference into the Law of the Sea Convention. This also presumably includes acceptance of the jurisdiction of the International Court of Justice by declaration or by agreement in accordance with Article 36 of its statute, whether or not express reference is made to the Law of the Sea Convention. The same may be true of regional courts. It may be recalled that the European Court of Justice, in concluding that Ireland violated community law in submitting the Planck dispute with the UK to arbitration under the Law of the Sea Convention, stated that it follows from Article 282 of the Law of the Sea Convention that the system for the resolution of disputes set out in the EC Treaty must, in principle, take precedence over that contained in Part 15 of the Convention. In this connection, I think it is very important to distinguish Article 282 from Article 281 of the Law of the Sea Convention. Article 281 accords much more limited deference to agreements on settlement of dispute procedures that do not entail a binding decision. Article 281 delays, but it does not exclude, resort to compulsory jurisdiction provisions of the Law of the Sea Convention, provided that the other agreement does not exclude any further procedure. The Southern Bluefin Tuna Arbitration Award concluded that the exclusion of resort to a further procedure need not be express, but may be implied. That conclusion has not been embraced in subsequent cases. This rejection of the analysis in the Southern Bluefin Tuna Award would appear to be consistent with the underlying proposition that some international court or tribunal should have jurisdiction to render a binding decision in the dispute subject to compulsory jurisdiction under Section 2 of Part 15 of the Law of the Sea Convention, at least absent express agreement between the parties to the contrary. The object, as the Permanent Court of International Justice stressed 90 years ago, is to prevent the possibility of a negative conflict of jurisdiction involving the danger of a denial of justice. Now, that said, the Convention itself contains important exceptions to this proposition. Articles 297 and 298 set forth limitations and exceptions to compulsory arbitration or adjudication under Section 2 of Part 15 of the Convention. Yet, those two articles also contain an unusual alternative in some of the specific situations where compulsory arbitration or adjudication is excluded. They permit either party to the dispute to submit the excluded dispute to conciliation, although the conclusions of the conciliation panel are not legally binding. Natalie is going to address this matter in greater detail in a few minutes, and I will accordingly limit myself at this juncture to proffering a paradox. Compulsory conciliation applies only where there is an exception to compulsory arbitration or adjudication under the Convention. The broader the competence or subject matter jurisdiction of a conciliation panel under the terms of Article 297 or 298, the broader the apparent exception to the jurisdiction of ITLOS and the ICJ and arbitral tribunals under those same articles. If we bear in mind that the state that did not initiate the conciliation proceedings may well also be the state that wishes to avoid adjudication or arbitration of the dispute, it is by no means clear in the particular context of compulsory conciliation proceedings that the interests of both the state that submitted the dispute to conciliation and the other party to the dispute are adverse to each other on the question of the scope of the exception to compulsory arbitration or adjudication under the Convention. At least to that extent, I think we have to treat jurisdictional precedent from conciliation proceedings with very great caution. The fact that Article 287 of the Convention renders arbitration the default system should not divert our attention from standing international courts. In this connection, we need to recall that unlike ad hoc tribunals, their members are elected on a broad base. Standing courts also form part of a broader institutional structure. As Judge Tomka just pointed out, the Charter expressly refers to the International Court of Justice as the principal judicial organ of the United Nations. While there is no comparable reference to ITLOS in the Law of the Sea Convention, it is one of the three institutions created by the Convention itself. And there is an express link between two of them that is sometimes overlooked. The Convention makes clear that while contract disputes between the International Seabed Authority and a minor are to be submitted to commercial arbitration, any question that arises regarding the interpretation of Part 11 of the Convention and related annexes must be referred to the ITLOS Seabed Disputes Chamber for a ruling. I think it should be evident from this provision that concerns about review of institutional regulatory powers by ad hoc arbitral panels are neither novel nor limited to bilateral investment treaties. The Convention does not expressly address the relationship between the Commission on the Limits of the Continental Shelf and either ITLOS or any other tribunal. For some time, both the ICJ and arbitral tribunals either declined to proceed to delimit overlapping continental shelf entitlements beyond 200 miles or found means to avoid the need to do so. It was ITLOS, as I pointed out in the Bay of Bengal case, that was the first international tribunal to delimit the continental shelf beyond 200 miles. Among the 136 paragraphs expressly devoted to the analysis of that issue in its opinion, paragraph 373 may be of particular interest in the context of our topic today, and I read it. The Convention sets up an institutional framework with a number of bodies to implement its provisions, including the Commission, the International Seabed Authority, and this tribunal. Activities of these bodies are complementary to each other so as to ensure the coherent and efficient implementation of the Convention. The same is true of other bodies referred to in the Convention. End of quote. While the last sentence that I just quoted expressly acknowledges the role of other bodies referred to in the Convention, one wonders how likely it would be for the paragraph as a whole that I just read to, with its particular institutional perspective, how likely it would be for some other court or tribunal to have written the same paragraph. I have my doubts. In concluding, I'm constrained to acknowledge that we are faced with a sometimes daunting array of fora as well as factors relevant to a choice among them. If this is relatively new to public international law, it is a standard feature of municipal law and private international law. It may well be regarded as a sign of maturation, which appeared to have been the view expressed some time ago by Rosalind Higgins, as the idea of compulsory jurisdiction, long accepted in municipal law and private international law, takes firmer hold in public international law. True, the complexity on which I touched may have been born of expediency. But like many other developments in the law, it survives and thrives because it has come to serve a useful purpose. Thank you.
Thank you very much, Bernie, for this, as usual, illuminating remarks. I give the floor to Natalie Klein. Be careful here. Yes, be careful. You are on the brink.
Good afternoon, everyone, and I'd like to echo Professor Oxman's remarks in thanking Hélène and Timor and Marco and Eric for the invitation to come and speak at what has so far been an excellent conference, and certainly I feel very privileged to be sharing a panel with such luminaries in the law of the sea. My particular task today is to talk about a fairly recent process, which is the first compulsory conciliation that has been conducted under the UNCLOS dispute settlement, which Timor-Leste commenced against Australia in 2016. And to ask the question, as we come to the final moments, it seems, of that process, as to whether this is a harbinger of dispute settlement under UNCLOS. Should we now expect to see more of these processes as a result of what we know about this procedure? So in talking about that, I'm going to give just a brief background, quite an abbreviated background on the Timor Sea, and then talk about the conciliation process itself to the extent known, and then try and answer the question that has been set. In terms of background in relation to the Timor Sea, it's actually probably easier to look at a picture, and this was one of the maps that was provided by Timor in its opening statement to the Conciliation Commission. So Australia and Indonesia had concluded maritime boundaries, you'll see, on either side of Timor-Leste in the early 1970s, leaving what became known as the Timor Gap. And after Indonesia integrated East Timor, or otherwise after Indonesia invaded East Timor, Australia moved to conclude an agreement with Indonesia setting up a joint zone for resource development. When Timor gained its independence in 2002, it concluded the Timor Sea Treaty with Australia, which again set up a revenue-sharing arrangement with 90% of the revenues going to Timor and 10% to Australia. But what you might just be able to see on the maps is that at the very side is the Greater Sunrise gas field, which wasn't fully within the joint petroleum zone. So another agreement was concluded, which is the Treaty on Certain Maritime Arrangements in the Timor Sea. And there were two key purposes with this treaty. It was to divide the revenue 50-50 between Australia and Timor. And also, it was to defer consideration of a maritime boundary between the two states for a period of 50 years, or otherwise 5 years after the exploitation of the Greater Sunrise field. The view that the permanent maritime boundary should not be resolved at this point of time was clearly set out in Article 4 of that treaty with a moratorium, and you'll see an extract from that in Article 4 of paragraph 4. So, notwithstanding any other multilateral agreement binding on the parties, neither party shall commence or pursue any proceedings before any court, tribunal, or other dispute settlement that might raise or result in, directly or indirectly, issues or findings of relevance to maritime boundaries, which of course raises the question, well, how did we get to conciliation then? Certainly, Timor was not happy with the arrangements. And I've just put up here another slide used by Timor in its opening statement, which showed a proposed boundary from Timor with its maritime boundaries, which you'll see did cut into the existing boundaries between Australia and Indonesia, and also enclosed all of the Greater Sunrise oil field. But Timor's only option in terms of trying to resolve the permanent maritime boundary with Australia, there were limited options available. When Timor was gaining its independence, Australia changed its acceptance of compulsory jurisdiction before the ICJ to exclude maritime boundary disputes, and it also exercised its right under Article 298 of UNCLOS to exclude sea boundary delimitations involving delimitation of the EEZ and continental shelf from compulsory arbitration or conciliation. But as Professor Oxman has just pointed out, where we have that exception, the alternative available to parties is to turn to compulsory conciliation instead. So that is what Timor opted to do, and there are a range of conditions that need to be met for a country to be able to use compulsory conciliation under Article 298. And I'll go through those in a little more detail in a moment, because that was a source of issues for Australia. But I just wanted to note that in terms of the conciliation process itself, that under the terms of Annex 5 of UNCLOS, we see that the role or the function of the Conciliation Commission is to be able to hear the parties, to examine their claims and objections, as well as make proposals. And we see that the role for the Conciliation Commission is not a passive one of just receiving submissions and then making recommendations, but I think almost takes on a role of mediation in terms of being actively engaged, and that's endorsed under Article 5, which allows the Commission to draw the attention of the parties to any measures which might facilitate an amicable settlement. The Commission has 1 year to be able to engage in this process with the parties, and then is to produce a report. And that report is to record any agreements that have been reached, and failing agreement, otherwise the report will set out conclusions on all questions of fact or law relevant to the matter in dispute, as well as any recommendations. In establishing the Conciliation Commission, Ambassador Peter Taxer-Jensen was established as the chair. Australia appointed Dr. Rosalie Balkan and Professor Don McRae, and Timor-Leste appointed Judge Karoma and Judge Wolfram as the members of the Conciliation Commission. Now, to look a little bit in more detail at some of the conditions that we need to address in turning to compulsory conciliation, I've divided these into 6 conditions that need to be considered if compulsory conciliation is to proceed in relation to a maritime boundary dispute. The first is that the dispute must have arisen subsequent to the entry into force of UNCLOS. And this was a critical issue in this particular case because Timor had only become a party to UNCLOS in 2013, which was definitely after the dispute had arisen. A second condition is that no agreement is reached in negotiations within a reasonable period of time. And this largely, I think, reinforces the obligations that already exist under Articles 74 and 83, as well as Section 1 of Part 15 around requirements to negotiate. The third condition is the dispute does not involve the concurrent consideration of disputed territorial disputes. This was probably the one condition, well, it was the one condition that did not apply in this particular conciliation. There was no contested territory, land territory between the two countries. Compulsory conciliation is not available for any sea boundary dispute finally settled by an arrangement between the parties. And I emphasize here the word finally because I think that excludes all of the provisional arrangement agreements that might have been reached between states. Compulsory conciliation is not available for any dispute which is to be settled in accordance with a bilateral or multilateral agreement binding upon those parties, which I thought would bring directly to the fore the considerations relating to the CMATS Treaty. And also the Conciliation Commission confirmed that requirements of Section 1 of Part 15 of UNCLOS would also apply. So this involves looking at the alternative avenues available for dispute settlement. In terms of testing these particular requirements, given what had been included in the CMATS Treaty and Australia's position that it was not keen to delimit a permanent maritime boundary, Australia did challenge the jurisdiction and admissibility of the Conciliation Commission. So in relation to some of those particular arguments that were raised, Australia did raise the question of when was the relevant date for the entry into force of UNCLOS for the two particular parties. The Commission considered that the relevant date was in relation to the entry into force of UNCLOS more generally, in other words, 1994, not 2013, and that this was the ordinary meaning of the unqualified phrase. So any presumption in favour of the non-retroactivity of treaties that might have normally operated was seemingly overridden in light of the plain meaning of that phrase. In relation to the requirement for negotiations, the Commission noted that there is no express requirement for negotiations in relation to conciliation, but rather that no agreement is reached within a reasonable period of time in the event that there are negotiations. And as a matter of fact, the Commission found that negotiations had been ongoing at various times between the two parties in any event. But I think more critical was really the effect of the CMATS Treaty. And this was a difficult question for a number of reasons, and one was a shadow that was hanging over these proceedings, inasmuch that Timor was clear to the Commission that it was planning to withdraw from this treaty, and so it would be terminated. And also, there was an arbitration ongoing at the time where Timor was challenging the validity of the CMATS Treaty based on allegations that Australia had been spying on Timor during the negotiations of the CMATS Treaty. So there were genuine questions around that particular treaty and its status. So in considering the CMATS Treaty, there were a few different considerations that needed to be given by the Conciliation Commission. First, in relation to Article 281, the Commission considered whether the CMATS Treaty constituted an agreement under Article 281 to seek settlement of the dispute by a peaceful means of their own choice. The Commission characterised the CMATS Treaty as an agreement not to seek settlement of the parties' dispute over maritime boundaries for the duration of the moratorium. So as such, an agreement not to pursue dispute settlement for a stated period of time, according to the Commission, was not a dispute settlement means of the parties' own choice. There's no explanation as to why a bilateral agreement choosing very explicitly to resolve a maritime boundary dispute at a later point in time wasn't a valid choice of dispute settlement for the purposes of Article 281, nor was there any discussion of the actual dispute settlement clause in the CMATS Treaty, which was Article 11. In relation to the requirement about a binding bilateral agreement settling the dispute in accordance with the terms of that full agreement, it doesn't appear from the decision of the Conciliation Commission that this was fully argued by Australia and didn't seem to be directly addressed in the response. But it would seem to me that given the Commission's decision on Article 281 that this was not going to hold them back, the dispute that was in question would have been the permanent maritime boundary, and CMATS obviously did not provide a permanent maritime boundary. So perhaps the bilateral agreement could have been excluded on that basis in any event. It certainly didn't seem to give the Commission or even Australia pause, from what I know. And finally, there was the question about the fact that assuming the CMATS Treaty was a valid treaty, then was Timor acting in violation of its treaty commitments in instituting the conciliation? It seemed to me a fairly plain violation of the moratorium in relation to Article 4. But the Commission was of the view that this international law violation, if established, had to be addressed elsewhere. And I think it was correct to say that the Commission did not have the authority to consider or decide that particular question. But it does sort of raise questions which Professor Oxman was considering in terms of the interrelationship between different dispute settlement clauses and the dispute settlement regime in UNCLOS, in thinking about how those different regimes might operate. So the upshot of all of these different tests was that the Commission decided that it did have jurisdiction, the dispute was admissible, and the conciliation process thereby commenced. And a series of confidential negotiations then proceeded. And on the 1st of September, we got a very happy press release coming from the Conciliation Commission, noting that the parties have reached agreement on questions relating to the boundaries. There is apparently going to be a legal status given to the Greater Sunrise gas field and also arrangements around the exploitation of that particular gas field. We don't yet know the details. Those details are still being hammered out. And it was mentioned in the press release that that hoped to be done by October. So the full details remain to be seen, but at least it does seem that the parties have reached agreement, which I think is really a critical moment to have gotten to. So given where we stand at the moment, is there new momentum for resorting to conciliation? And I think we probably have to say yes. So far, it's looking quite good as a process to be able to resolve a long-standing dispute. But I do think we have to acknowledge that there are still a number of barriers. First of all, we know that in a number of the outstanding maritime boundary disputes that exist, they concern states that are not parties to UNCLOS, such as Turkey and Venezuela and North Korea. Also, we have not yet tested, and I think it remains a barrier, the fact that a number of some of the most contested maritime boundaries also involve disputed territory, and that still remains a barrier to using this particular process. And also setting the entry into force date at 1994, that's still going to exclude a large number of continental shelf disputes from this particular process. But I think we have seen various barriers reduced in the course of the conciliation between Timor and Australia. And I've included the entry into force date here, again, because it's been set at 1994. So any states that become parties after that particular date don't get to necessarily use to their advantage or have used against them a later date as to when the dispute might have arisen. And one point that I think is quite interesting here and remains to be tested in the future is that if states did not declare their exclusive economic zones until after UNCLOS entered into force, if their exclusive economic zones were declared in 1996-97, then perhaps this means that exclusive economic zones, overlapping exclusive economic zones, could now be subject to compulsory conciliation, even if the overlapping continental shelves could not be. On the arguments around the entry into force date, that would seem to be a possibility. And we'll need to think further about what that means for our common maritime boundaries. I also think that in terms of our negotiations requirement, the approach of the Conciliation Commission, I think, is consistent with the approach we have seen in UNCLOS dispute settlement more generally, where requirements to negotiate, that's a fairly low hurdle that has to be met for states to be able to institute proceedings. I think that was reinforced in this decision. And also, I think it seems, in light of what was in the CMATS Treaty, that it is unlikely that other agreements are necessarily going to preclude resort to conciliation. But we do have some untested aspects. One is just a technical point, which I don't think will be an issue this time around. But strictly under Annex 5, there's no requirement to publish the report of the conciliation. It has to be communicated to the Secretary-General. It doesn't necessarily need to be made public. Obviously, it's preferable for it to be public because that enhances transparency, accountability, and so forth. It seems that it probably will be in the context of Timor and Australia in any event. But what is untested and is a complicated provision within Article 298 arises in the scenario where the states don't reach agreement during conciliation. They then receive their report with their recommendations. They then go and negotiate. They still can't reach an agreement. Then, according to Article 298, they shall, by mutual consent, submit the question to arbitration or adjudication. It's so clearly compromised text when you have they shall by mutual consent. Are they required to go to arbitration? Do they have to consent to go to arbitration? The arguments will obviously go both ways on this particular point, depending on which side you are on, and we need to resolve this one in the future. Beyond these technical legal arguments, we also have to think more broadly about the conditions for successful dispute settlement, and particularly in terms of resorting to third-party dispute settlement. Ambassador Richardson, who was the chair of the Jan Mayen Conciliation Commission, the other successful Maritime Boundary Commission, noted that that process had been successful because it had entailed a careful assessment of the parties' interests. There was a practical approach to surveying the disputed area and a formulation of a framework for mutual cooperation. And we seem to have those same hallmarks in the Timor and Australia Commission based on what we know so far. And Professor Lindefork, writing about the Jan Mayen conciliation, also said, another condition of success will be when the disputing states already have a history of generally good relations and they are equally anxious that those good relations be maintained. I would say for Timor and Australia, the relationship has had its highs and its lows, but at least both states have informed the Commission that they are intent on creating a good relationship into the future. We would also need to consider the genuine interest of both parties in resolving the dispute, the support for conciliation as a means of resolving a dispute, and also the acceptability of the recommendations that are made throughout the process. So all this to say that I think while compulsory conciliation, we can now point to a recent example of where it's been undertaken and seemingly undertaken successfully, there are still a lot of different factors that will need to be assessed in deciding if it is the best path to resolve a maritime boundary dispute. Certainly it seems with the Timor-Leste and Australia process that if this particular process has resulted in Timor gaining its long sought after sovereignty over both its maritime and its land space and having its right to resources recognized, then I think we should probably consider that that stands as a success of the UNCLOS dispute settlement regime. Thank you.
Thank you very much, Natalie, for putting us up to date on this latest exciting development of dispute settlement system. And I'll give the floor to Liesbeth Lijnzaad. Please be careful.
Thank you very much, Judge Treves, and thank you very much for the organizers for inviting me to this very interesting seminar. Now, when Marco and I discussed the subject of my presentation, I agreed to speak to you about dispute settlement in the future implementing agreement on marine biodiversity beyond national jurisdiction. I've done some work on the subject, and I thought at the time that by the time the conference would have come, the PrepCom would undoubtedly have presented some suggestions as to dispute settlement. I have a problem here because they didn't really do that, and I perhaps should have known better. I know these discussions, they take a lot of time, they are difficult, so perhaps I'm going to speak to you more about the general issues, the general problems concerning a future implementing agreement on marine biodiversity beyond national jurisdiction. Now, I don't quite know how much you know about the subject, so firstly, I'll just take you in very big steps through the marine biodiversity discussion. Then I'll raise some questions as to dispute settlement, and thirdly, make some comments about some procedural aspects. Now, in 2004, during the annual meeting of ICP, the Intergovernmental Consultative Process on Oceans and Law of the Sea, ICP discussed marine biodiversity in areas beyond national jurisdiction, and the meeting was informed about the major threats to marine biodiversity beyond national jurisdiction, essentially threats created by fisheries activities out in the high seas, on unknown seamounts where ecosystems and unsurveyed habitats were destroyed by too aggressive fishing. These were activities in ecosystems of which science did not know quite enough in terms of reproduction time, in terms of the composition of the ecosystem, the interrelationships in the oceans and the interrelationship with the seabed floor. So too much going on in the high seas, not insufficient control, so there was a clear need for the international society to do something about it. Now, doing something about it started in, and I think this is United Nations par excellence, the ad hoc open-ended working group on marine biodiversity in areas beyond national jurisdiction, otherwise known as the BBNJ working group, that worked from 2006 to 2015. So they took some 9 years to look at this issue, initially, by the way, in 2-year intervals. By 2011, the General Assembly took a crucial step in the annual Oceans and Law of the Sea resolution, which included the so-called package, which is to be found in an annex to the annual resolution, where the General Assembly speaks about the initiation of a process that ought to effectively ensure a legal framework that effectively addresses issues the issues concerning marine biodiversity by identifying gaps and ways forward, including through the implementation of existing instruments and the possible development of a multilateral instrument under UNCLOS. And then, and this is what I think is a crucial element in the discussion that was to follow, that there was a need to address conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction, in particular, together and as a whole. The notion together and as a whole was a key element of the package, and that referred to the elements of marine genetic resources, including access and benefit sharing of benefits following from marine genetic resources, area-based management tools such as MPAs, environmental impact assessment, capacity building, and the transfer of marine technology. This package, so this is basically a list of criteria of what the General Assembly wanted the work to be about, has been an important framework for the further discussions in the working group and later on also for the preparatory committee. Working group finished its work early 2015, and then in the autumn of 2015, no, in the summer of 2015, I should be more precise, the General Assembly decided, in greater detail this time, to develop an internationally legally binding instrument under the Law of the Sea Convention on the conservation and sustainable use of biological diversity, etc., etc. It's an endless formula. So a preparatory commission was established with a mandate to make substantive recommendations on draft elements of an internationally legally binding instrument. In the meantime, for those of you who want to start following this discussion, that has now got the following acronym. We're talking about an ILB under UNCLOS, an internationally legally binding instrument. So it is about the ILB. Anyway, but the element, and that was, I think, quite a crucial element for many participants in the early discussion, there had to be a quite clear relationship between the convention and the future ILB. And the examples given, although they don't really tie, I mean, they're quite different, are obviously the 1994 agreement and the fish stocks agreement that are, technically speaking, also implementing agreements of the convention. Now, I've given you the list of all the issues that needed to be included, but that, in fact, wasn't really all. During the discussions in the working group, one of the repeated discussions has been the question as to, well, what is the problem that we are addressing, actually? Majority in the room G77 and the European Union would say there is a regulatory gap. Marine biodiversity beyond national jurisdiction is not addressed in the Law of the Sea Convention, and at the same time the Convention on Biodiversity is talking about biodiversity under the jurisdiction of the member states. So there is a gap. The other side of the room, a smaller group, although an important group, they were talking about an implementation gap. They were actually saying, no, if you properly look at what is out there, rules from regional fisheries management organizations, from regional seas organizations, lots of other organizations, they have bits and pieces of management tools and instruments to look at marine biodiversity in those areas beyond national jurisdiction. So the main thing we ought to do is we've got to bring all that together, make it perhaps a bit more accessible, and start to ensure implementation of what already exists. So these are two fundamentally different views. Now, whatever the your views are on these two questions, regulatory gap or implementation gap, that still would mean that you would have to deal with pre-existing rules somewhere in your system. If you say that that there is a regulatory gap, you'd still have to figure out, well, the bits and pieces that we have, where do we tie them up in the system? And if you say we have an implementation gap, you still would have to bring this all together somehow so that you could cover what is happening on the high seas. All of that is taking place against serious warnings from ocean scientists, and we've had many sessions where ocean scientists from different backgrounds, whether from academia, whether from other international organizations dealing with aspects of ocean management, have looked into what is really the threat and what is causing all of this, including the fact that while we do know a lot about what is happening in the oceans, we don't have a complete picture. There is so much of elements missing, and things are being discovered as we speak. So while it is important to take action, such action needs to be informed by scientific knowledge about marine biodiversity, which I would suggest is far from complete. Also, if we start today, the odds are that next month we will find out more and more. So legal work may be not in the right timing with what science is telling us, how science is developing on what is happening in the oceans. Also, this discussion takes place against the background of what I've casually called the history of the Law of the Sea Convention. So there were some casual comments about marine biodiversity in areas beyond national jurisdiction is the common heritage of mankind. Oops, so half of the room is getting extremely worried. It's not helpful to get into that debate because it is really stalling the debate, but there are a number of delegations that are quite clearly talking about common heritage of mankind because, well, in their view, anyone could read that in the convention, whereas the other side obviously thinks that's never been in the convention and we're not getting it there either. Okay, so the PrepCom concluded its work this year in July with also, I would say, typically United Nations. It took a consensus decision to report to the General Assembly that no consensus could be reached on a multitude of issues, and they are, in fact, the issues that I have mentioned are mentioned in the package. That doesn't stop the momentum to moving towards an intergovernmental conference in 2018. It's not yet been formally decided, but it is very likely that it will be decided sometime this year. And that makes this, I think, a time to start reflecting on dispute settlement. I would say, though, that in terms of moving to from a PrepCom to formal diplomatic negotiations, the paper that we have, the advanced unedited version, is on the website. It is not the type of thing that you would expect from a preparatory commission. It is essentially a list of headings with a number of added details as to what should be addressed. It does by no means look like a sort of treaty in the making, which is what you would normally see in a situation like that. Now, as I just mentioned, the negotiators have so far not provided great detail as to how they would see dispute settlement with respect to matters concerning marine biodiversity. I'm just leaving out the rest of the formula. You know what I'm talking about. The final report is extremely succinct on dispute settlement. It's barely one or two phrases. There ought to be a provision on dispute settlement. Oh, it's difficult to disagree with that, but what it would look like is hardly indicated. What is relevant, though, is I think that there is a reference there to also a separate discussion that took place with respect to responsibility and liability, where one delegation referred to a similar provision in the fish stocks agreement. I think that's Article 35 of the fish stocks agreement, and where the European Union said that the articles on state responsibility were quite enough, so we do not need a provision. That's one element that I think would be of relevance when looking at dispute settlement. And another element that is, I think, equally important is that the report does give us a sketch about future institutional arrangements in the future ILBI that would seem to encompass a decision-making body, just similar like a conference of the parties, a scientific and technical body, and a secretariat, as well as a clearinghouse mechanism. So all of that looks very much like, I would say, the structure of contemporary environmental treaties. Now, clearly, when you're looking at formulating a dispute settlement system, the content of the instrument to which that is going to be attached will be very relevant to how you shape a dispute settlement system. Creating such mechanisms relies on the perceived potential disputes, the types of cases to expect, and indeed what kind of dispute settlement may be necessary given the object and purpose of the future instrument. So these are design questions that are based on expectations with respect to potential violations of substantive norms, but equally on ideas about the potential parties to disputes and the nature of their legal interests. Although it is tempting to think that a simple reference to Article 287 would do the trick, I'm not sure if that will work. I think this may require some more in-depth analysis. Of course, Article 30 of the fish stocks agreement with the mutatis mutandis formula is an example of such a more or less simple connection to refer to a pre-existing dispute settlement. I'm not really convinced that that will work. So it requires us to look somewhat more specifically at the content and the thinking behind this project as it is developing, and I am sorry that we don't have more solid ground under our feet. First of all, I'd like to comment that in all of this, there is a slight misnomer. We seem to all be focused on the areas beyond jurisdiction, beyond national jurisdiction. But even if there is no territorial jurisdiction from the coast state, the majority of those activities would still be taking place under somebody's jurisdiction, the jurisdiction of the flag state or the jurisdiction of the national state of the company or the national state of the individual. So while the geographical area beyond national jurisdiction seems to not necessarily point to a role for the coastal state. Other jurisdictional links must be a starting point. And when we look at disputes at international level, what kind of disputes are we really thinking about could arise under this new instrument? Conflicts between states. Well, since we're talking about international dispute settlement, conflicts between states would be the obvious structure, but perhaps also conflicts between perhaps states and international organizations, or let's be bold, between states and individuals. I don't know. At the moment, it seems highly unlikely that individual rights would be created under the ILB, although that some delegations have referred to the deep seabed system. I don't think that has been accepted broadly, so they would be looking at the seabed authority, etc. I don't think that that is a thought to entertain, but at the same time, can we envisage a situation in which individual investors in commercial activities related to, I don't know, the sustainable use of marine biodiversity might have to obtain licenses from their states or from an international licensing system for private companies or state enterprises? That is at the moment not yet foreseen, but who knows? Particularly if we go into the position of investors in activities related to marine biodiversity. Of course, this is the sustainable use element of the subject we're looking at. We get into questions of the security of investment and the related property right issues that would then would have to be dealt with somewhere. Now, if that goes in a sort of two stages approach, the investor has a relationship with a state, and the state is the as it were, the go-between. Then in that situation, we're still in the interstate level as we talk about the rights under the new instrument. If that's not the case, we would have to look into these issues, but that would also, I think, include a requirement to ensure that the standards in the new instrument are properly translated in domestic legal systems. Related to that is questions about marine genetic resources, access and benefit sharing. That also moves into the area of property rights, and it has been one of the elements with which the discussions have been extremely confused. It has been also very difficult to obtain the right kind of expert advice on these elements. Apart from, obviously, fishing, there is this thought that we are all going to get rich because of all these wonderful marine genetic resources that we're going to find on the high seas, and we're all going to make money out of the patents that will be developed on the basis of those of that riches. I'm exaggerating here because I suspect that I'm not really personally believing that, but at the same time, it brings a discussion of what started out in the eyes of many as a nature conservation project into quite a different field of investment and of patents and stuff like that. And it is a sort of an uneasy tension in those discussions. That brings me to an issue that I have spoken about elsewhere already, and it is about the what is at the core of these discussions, the conservation and sustainable use of marine biodiversity. Now, I believe the question must be raised as to, is that one notion, so it is conservation and sustainable use in one box, and the presumption is that we can work towards that goal with a more or less unified set of measures. Or, alternative two, these are two distinct notions. The instrument may be about the conservation of marine biodiversity, and it will also be about the sustainable use of marine biodiversity. if that reading would be correct, there may be situations in which activities that may be beneficial to the conservation side of things may be an impediment to the sustainable use. Let me give you an example. If for conservation reasons a particular area is a closed-off area, for instance in a marine protected area, as decided by, let's assume, a conference of the parties to the future instrument, there might still be individual investors that are going to go and find these wonderful creatures that they will use for their genetic resources, and end up, I don't know, hunting for them in areas that are closed off by an MPA. Or, well, there are many of those. I'm not going to go into the details because that would be taking much too long, but one wonders how conservation measures, such as the establishment of MPAs by organs of the new instrument, or indeed by regional FMOs, will go together with perhaps a licensing system for marine genetic resources by states parties. All of this leads to potential conflicts that at this stage I don't think we can fully understand. So I'm really only suggesting to you that the matter is much more complex than it looks, and certainly more than the one sentence that is devoted to it in the report of the Preparatory Commission. If I may, I wanted to make 3 points about procedure. Now, during the negotiations, I'm going to try and do this very rapidly.
Yeah, very close. Time limit.
Right. During the negotiations, a number of delegations were very much in favor of establishing a particular BBNJ chamber within the Law of the Sea Tribunal, and even went so far as to elaborate on what it takes to amend the convention, and etc., etc. I think many in the room had the idea that that would perhaps not be a great idea. Obviously, it is possible under the statute of the tribunal, I think it's Article 15, to create a special chamber. So if there is a great desire to establish something like that, and probably the tribunal should listen well to discussions in the meeting of the states parties, it is possible to set up a separate chamber on marine biodiversity. Now, another aspect, and I discussed this issue with students, is that my students were extremely interested in maybe setting up another list for special arbitration. Now, special arbitration, I think we all know its 3 main characteristics: the matter of the 4 lists with arbitrators. The lists are very difficult to find. I don't think they're up to date. Unfortunately, they're not on the DOALOS website. The fact that the Secretary General acts as the appointing authority in special arbitration, and most of all the fact that it has not yet been used. I'm not sure about this idea of creating a 5th list with special arbitrators. I would think if that would be the idea, it should be people with expertise in marine biodiversity. I would say the beyond national jurisdiction element is for the lawyers, but the marine biodiversity element might be an element on which to constitute a separate list. At the same time, out of the 4 lists that exist at the moment, 3 may already provide the type of expertise that might be needed. Also, I would say there is perhaps not a need to refresh an interest in special arbitration. I do believe that with ordinary arbitration, and there is technically speaking no impediment to have a look at the lists for special arbitration if you want to find the right expert to be on an arbitral tribunal. And then finally, and this was mentioned by a number of delegations during the negotiations, it seems to me that certainly the possibility of an advisory opinion from the Law of the Sea Tribunal is something to include in the new instrument. The conditions for that, I think, are precisely set out in case 21, so I'll leave it at that and won't go into detail about that case. Thank you very much.
Well, we have had 3 extremely rich reports, which unfortunately have eaten up a lot of the time that otherwise would be given to discussion. But still, we can entertain questions or observations for about 10 minutes. Nobody wants to deprive you of your lunch, even though I alone would be able to fill the 10 minutes with questions, but I will abstain from doing so. So the floor is open, please. First, Alexander Perls.
Thank you. I volunteer for stealing the time for the lunch break. Sorry for this. Thanks for the 3 excellent talks. My question goes to Liesbeth and is in relation to the marine genetic resources issue. As you rightly pointed to the intellectual property rights, I was wondering, or rather, I would consider this as one of the crucial points, taking into account that we are not speaking of resources that you take individually, but rather you pick up one and then start genetic screening, which makes intellectual property rights one of the centrally important issues. The question is, does this not push the entire story towards the WTO and towards the dispute settlement mechanism of the WTO? And I guess perhaps that is not really what most international environmental lawyers would want to happen. My question thus, has there been any discussion on the overlap of the regimes of the future ILB on the one hand and the WTO regime on the other? Thank you so much.
Thank you. Perhaps we take a few more questions before answers. Professor Boyle, Alan Boyle.
I suppose a quick question for Professor Oxman. He can probably see it coming. The recent jurisdictional decision in Somalia, Kenya, gave us an interesting view of the relationship between Article 36 of the ICJ statute and Part 15 of UNCLOS. Do you think it's a coherent vision, or do you think it's an incoherent vision?
Thank you. Please. We have somebody in the middle. Here.
Vivek Chandra, just PhD student. Just a question for Natalie. I just want to get a clarification. I thought I wrote down that EEZ overlapping claims can be going into conciliation, compulsory conciliation, but continental shelf ones cannot. And I just wanted to understand that a little bit better. I didn't realize there was a difference. Maybe that shows my ignorance. So thanks.
Thank you. One more question, and then we have some answers.
Sean Murphy. This is based on Natalie's presentation, but I'd be interested in others' views as well. The idea that after a conciliation, compulsory conciliation takes place, what then? It is this interesting language about shall, by mutual consent, submit. And it seems to me one possible interpretation of that is that it's not a firm obligation because you need mutual consent. And the other possibility is to interpret it as both sides must offer up one of the 4 forum as a place they're willing to go. And if the other side accepts, then that's going to be the forum you would go to. So I'm curious whether you have views as to which of those 2, or whether there's a 3rd or 4th way of interpreting the language. And also, if it's a firm obligation to offer up a place that you would go and the other side accepts, should we be rethinking the exceptions? That is, some states that are considering whether to join the convention draw comfort from the existence of these exceptions. But if at the end of the day, you still may well end up before binding dispute resolution, even if it's relating to military activities or something else, doesn't this maybe force us to think a little bit differently about the utility of the exceptions.
Thank you. Well, I think we can have some answers now, and perhaps just a few more questions. Who wishes to take? I think Bernard and Natalie were, both, the two of you had received your own question. Shall we start with Liesbeth?
Yeah, the question on marine genetic resources. Well, during the debates at various instances, it was very clear that this element of intellectual property rights created a huge confusion. Also, what didn't really help was we tried to get WIPO involved to tell us some more about it. I'm not sure if that really helped. I thought that we were sort of confused at a higher degree. What I would say is what makes it also very complicated is that the organisms from which to take these genetic resources may not necessarily only exist beyond national jurisdiction. They may be in somebody's EEZ as well. Would that take it to WTO? I'm not sure. But it very much goes, for me, very much comes down to what I think is a fundamental question. Is it conservation and sustainable use in one go, or has this new instrument one goal, or has it got two goals? If sustainable use is one of the goals, well, then you'll be setting standards for what to do in all the fields that are commercially interesting, marine genetic resources, fisheries, and maybe others. And moving from that, you might end up in WTO, but then I'm not an expert on WTO, I must admit.
Thank you. Natalie.
Just to clarify the point around the EEZ versus continental shelf, it was in relation to the entry into force date. So there has to be a dispute that arises subsequent to the entry into force of UNCLOS, and I was suggesting that it is much more likely that EEZ disputes have emerged subsequent to the entry into force of UNCLOS, since the EEZ is a creation of UNCLOS and states may not have declared their exclusive economic zones until post-1994. They might have had fishing zones prior to that, but more likely, I don't know the state practice, it might be interesting to look into. More likely an EEZ emerged after that, and I think a state that wants to go down this path could argue we have overlapping exclusive economic zones and that dispute only emerged subsequent to UNCLOS, whereas it's much more likely the continental shelf being an older institution, the disputes relating to overlapping continental shelves would have been more likely to arise prior to '94. In relation to the language about shall by mutual consent, I think that's actually an interesting way of kind of giving some substance to what states are required to do in terms of they must, offer up one of those particular options. I have been thinking about it previously in terms of to what extent are they required to go to any form of compulsory arbitration or adjudication. And, there are arguments on both sides. On the one hand, you can say that shall by mutual consent, that there needs to be some extra manifestation of consent still at that particular point. That's consistent with the fact that there was an optional exception in the first instance. It's consistent with the substantive provisions around maritime delimitation that preference agreement as the initial point around that. But you have your counter-argument where you go, well, UNCLOS dispute settlement's all about getting as much as possible into compulsory arbitration and adjudication, therefore we should favour states moving in that direction. But I don't have a firm view at this point on which way it is likely to end up. Certainly it seems at the moment that an expansive approach to compulsory jurisdiction is the flavour of the day, so more likely it might happen. And certainly the way you suggest seems like a way of requiring states to flesh out that obligation.
Thank you. Bernie?
On Somalia, Kenya, in my remarks, I addressed only the point on which the two states agreed, which was that the declaration accepting the jurisdiction of the International Court of Justice in effect, mutual declarations, had the effect under the law of the sea convention of removing that system and using the ICJ system. The particular issue in that case is, of course, the problem of the mutual exclusions. There was an exclusion in Kenya's declaration, and that, in a sense, matches the exclusion in the law of the sea convention. The part of that that I found personally particularly persuasive, and I don't think that will surprise you, is that there was no way for the International Court of Justice to assure that if it found that it didn't have jurisdiction under its own statute, that there wouldn't be a subsequent decision by the Law of the Sea Tribunal or an arbitral tribunal that they didn't have jurisdiction under the Law of the Sea Convention. The ICJ couldn't assure that its own analysis would be matched with an assumption of jurisdiction by an arbitral tribunal, and that got you into the problem posed 90 years ago in the PCIJ case, and that is that kind of a difficulty. So I certainly would not characterize it as incoherent or whatever. I do want to say 2 words on Sean's comment. One, I consider the exceptions to jurisdiction to continue to perform a very useful purpose, although I have to confess that I am somewhat surprised that the coastal states, especially in Latin America, that demanded the limitations on jurisdiction under Article 287 have not reacted more sharply, shall I say, to the conclusion in the Chagos dispute that those were not exceptions but rather expansions of jurisdiction. And it may be that, as Michael has made the point, elsewhere governments decide to wait for an opportune time to express their views. Obviously, we will find out as cases go on what the exact content is of these exclusions, but I wouldn't eliminate them. Very fast word on mutual consent. Whatever one's view of whether it does or does not create a legal obligation, I have grave doubts that that obligation is subject to compulsory jurisdiction under the convention, which is the subsequent question. If you do have an obligation, is that obligation itself subject to jurisdiction? And that raises yet another issue which we don't have time to address.
Thank you. Well, I think we should finish, but if there are a few more questions, we will entertain them. May I put a question to, do you think that the decision of the Conciliation Commission on the entry into force, the interpretation of the entry into force, will be followed by other courts and tribunal or conciliation commission? If we're counseling a state with a different interest, I think it would be worth trying
again.
That.
Yes, well, we've seen that different bodies under UNCLOS can take different positions on the interpretations of clauses. Obviously, the southern bluefin tuna versus South China Sea being a key example in that regard. So we can always anticipate that an UNCLOS dispute settlement body will change its institutional mind. Whether it would change it on this particular point, I think it's unlikely, actually, even though I had argued otherwise. My opinion was rejected by the Commission. And I suspect that the plain meaning approach would probably prevail before another commission, but I think these things can always get argued in any event.
Thank you.
Just a factual remark in relation to the question of Professor Boyle and the answer by Professor Oxman. Certainly I'm not going to comment on the judgment, but the factual information is this one. Following a vote in the deliberation room on 20th of January, 21st of January, Friday, the registrar informed the parties about the date of the delivery of judgment of 2nd of February. On Monday, 24, January in New York, the respondent deposited with the Secretary General a declaration excluding maritime delimitation disputes under Article 15, 7483 from compulsory jurisdiction procedures. So had the court decided otherwise, there would have been no avenue to decide the matter. That's a factual remark. Because I have noticed that some young scholars from this institute commented on the court's judgment. I'm not taking issue with the comments on in the blogosphere and the Agile talk, but certainly they were not aware of that information because that information was not yet publicly available when the judgment was rendered. Thank you.
No further interventions. So I think we have to thank the three reporters, the three interveners, for their very rich and stimulating looks at the past, present, and future. And good lunch.